how ironical it is that in this intellectual sense, you were more free in China than you are here in Canada.
In China, we have a much more rules than Canadian, but it
Mm.
is not rule of law. It is a dictatorship.
Hello, everyone. Welcome to another episode of Grey Matter. Well, most Canadians are unaware that professions like law, medicine, and psychology are actually supervised by self-governing societies. They were created by statutory law to be self-governing so that they would be independent of government control or ideological influence. Well, today we'll be speaking to a couple of courageous Alberta lawyers who spearheaded a petition against mandatory Indigenous sensitivity training by their law society, training which really has no relevance to the competency of lawyers practicing in the province. We'll discover why they did it, what happened to the petition, and most importantly, what they intend to do about it. They are Roger Song and Glenn Blackett. Welcome to Grey Matter, gentlemen.
Thank you.
Thank you.
Perhaps we could start with, as we usually do, with our framing aphorisms. Again, some of these are chosen in the honor of our guests. The first one is from someone I mentioned in the opening. This is Dr. Jordan Peterson, who wrote, "A world without freedom of speech is a world of slavery and tyranny." From C.S. Lewis, a quotation that I've mentioned on this program before. "Of all tyrannies, a tyranny sincerely exercised for the good of its victims may be the most oppressive." And finally, from St. Thomas More, who is you might know as the patron Catholic saint of lawyers, lost his head for challenging the King of England, who wrote, "One of the greatest problems of our time," it's still our time, "is that many are schooled, but few are educated." So on the show today, we have Glenn Blackett. Glenn is a civil rights lawyer working in Calgary with the Justice Center for Constitutional Freedoms. We also have Roger Song, who has an extensive international legal experience and language skills. Roger helps Canadian companies and entrepreneurs to develop business relationship and opportunities and in negotiation and to close commercial transactions with Chinese partners and companies and make investment in province of Alberta, mainland China, and Asia market. And he is also a lawyer, as we said, in the province of Alberta. So perhaps we could start with Roger. Roger, I understand that you were very intimately involved in the launching of a petition that was signed by a number of Alberta lawyers, including myself, against a mandatory course on Indigenous history. Would you perhaps start out by telling us a little bit about the petition, how it got started, and why you did it?
Okay, well, thank you, Gray. Okay, so we sent out a letter to the profession July 13, 2022. Basically, we ask our peers to endorse our petition to repeal Rule 67.4 of the rules of Alberta Law Society. And that rule basically says the benchers have the power to impose whatever specific education they think are in the interest of the public to all the professions of Alberta under the penalty of automatic suspension. In other words, they have the power to impose whatever education they believe that we should take, and if we disobey, they have the power to automatically suspend our legal license to practice. So personally, in order to get that license in Canada, I endured 7 years law schools in Beijing, in China. I got my LLM degree from NYU and have my license to practice in New York. And then I came back. When I came to Canada, I went back to law school at the University of Calgary, do my 3 years JD, and do my 1 year article. And finally, I got my license to practice law in Canada at age of 50. So in other words, under this rule, the law society just can't suspend my license to practice law in Canada just because I don't want to participate their doctrination. I think, to be clear, our petition is not about the First Nation issue. In our letter, uh, July 13 to the profession, uh, Mr. Benjamin Furland and I co-authored this letter. We make it very specifically saying, to be clear, we do not oppose Rule 67.4 based on a belief that understanding Indigenous culture is unimportant. Rather, we oppose it because we do not believe the benchers have or should have the power to mandate cultural, political, and ideological education of any kind on Alberta lawyers as a condition of practice. We believe the profession and our clients are best served by an approach to CBD, recognizing that individual lawyers and firms, not the benchers, are best situated to understand and address their CPD requirements and professional needs. So that's the basic background of the.
Mm.
So we start from there, June 17, 13, we send out letter, and gradually we receive the signature support of lawyers, and eventually it still took me like 7 months uh, or maybe 5 months to get the required 50 signatures, right?
Mhm.
Because I'm a new immigrant. I have no connection. I'm a sole practitioner, right? I'm not well connected. So that's the background. Yeah,
Mm.
later.
So, Glenn, you're obviously a lawyer who's involved specifically in human rights, civil liberties, with the Justice Center for Constitutional Freedoms. This is obviously something that's of concern to you and also to the Justice Center. Do you want to explain a little bit what the essence of this is? Because I know that in the media, in the mass media, this has been misplayed as some sort of racism or bigotry or insensitivity to Indigenous peoples, but it really has nothing to do with that, does it?
Well, it depends on your definition of racism, I suppose. If by racism you mean opposing any particular viewpoint, then I guess it is a kind of a racism.
That was Trotsky's original definition, I think.
Oh yeah,
Yeah,
there you go. Perfect. We're right back to where we started.
that's it.
Yeah, I mean, and I've said this a million times. The every petitioner signed the petition for its own reason, and
Mhm.
I signed the petition for my own reasons. I wouldn't even say they're the Justice Center's reasons. I didn't sign it as a member of the Justice Center, although that's what I do as a living. But my opposition was both, I'd say, the mode and content of that training. And by mode, I mean, the authoritarian style with which it was handed down by our law society. I don't think that if you look at the Legal Professions Act, it's at all clear that they have the power to impose any CPD or be involved, frankly, in CPD in any way. They had an old rule, 67.1, 2, and 3, which said, there's some criteria that they imposed saying, it's got to relate to your practice or ethics or law or something, but you have to be doing CPD and you have to report to us what CPD you're doing. And even that rule, I mean, I didn't have a problem with it because it was easy to comply with, and it still left me in charge of deciding what I need to do to ensure that I am competent in my practice, given my particular, practice and clientele. Even though I didn't have a problem with the rule, I still didn't think they had the power to impose it, but that's fine. So I complied with that rule along with every other lawyer, I think, or most other lawyers. I don't think it was well enforced, and I don't know that anyone read my plan to see if they liked it or something like that. But Rule 67.4 was, the next level of intrusion into the lawyer's independence. And instead of saying, well, we have the power to ensure that you're doing CPD, they took the power to impose particular CPD. So, I don't care what practice area you're in. I don't care what your clientele look like. I don't care what your history is. I don't care what doctorate you might have in history. You're going to do this particular kind of training because according to the Law Society, it's going to make me more competent to practice as a lawyer, which, I mean, for the most part is kind of absurd because I don't deal in Indigenous law very often. So the mode of it, imposing that training. And I should mention too that when the Law Society imposed that additional form of CPD where they could tell lawyers exactly what to do under Rule 67.4, they excused themselves from all of those requirements under the rules that training relate to things like substantive law or professional ethics or any of that kind of stuff. And I think that was probably wise that they do so, because the path didn't seem to align with that concept of professional development at all. Mm-hmm. So that was part of my problem. And then I think I stand apart from many of the petitioners in that I opposed the content of the path as well. I thought it was a bad history. It was a slanted history. It was a bad and slanted history for the purpose of driving home a propagandistic point. And it was bad politics. It suggests, it basically suggests a number of policies, let's say, that fine, you can propose those policies, but those policies should be something that are, first of all, presented in the public forum, in the democratic forum where you're presenting it to elected legislators. I think that, we have this theory that we now base our policy on evidence. Therefore, I think it should have been an evidence-based policy argument, which would require looking at evidence on both sides of the issues that they've presented, and, should have been presented along with advocates of opposing positions. And I would take as maybe the figurehead of that movement, maybe a Francis Whittleson or a Tom Flanagan, to talk really about, I think their proposal would be that, economic integration is how you enhance the economic outcomes of a society, not economic isolation. Mm-hmm. And so, I had substantive objections to the content of the path that I don't think were shared by many. And I don't think they were shared by many because they wouldn't if they knew more about it. But the more you unpeel that onion, the more it makes you want to cry for the validity of it.
Roger, I'd like to come back to you because you mentioned, you shared that you come from China. This must have been especially troubling for you, given that you left a society in which let's face it, civil liberties and that sort of thing are suppressed. A society in which censorship is normalized, and in which indoctrination is really part of the culture. I take it you probably came to the West, the United States and Canada, to escape all this. So this must be especially troubling for you to sort of have this mandatory investigation, and almost like a post-traumatic stress situation for you. You want to talk about that a little bit?
Yeah, thanks, Leighton, you raised that. Yes, exactly. So when I see the notice from the Law Society saying this is the cultural competence requirement, so they use specifically the word cultural competence, that immediately reminds me of another phrase called cultural revolution or political competence in China. So when I was in China, I received 22 years 17 years education. I was working as a professor at the university, Beijing University Law School. I have to take one specific subject of course. That course is called Competence of Ideology. Basically, that course is a doctrination of Marxist communism ideas and regime and worldview. I have to take that course from grade 1 up to my graduate school. If I fail that subject, I cannot be advanced to a higher level of education. I cannot be admitted into the school that I want to go, right? So that is that I really hate that type of indoctrination course, because I have to memorize everything. I have to critically accept everything they told me and put it on paper, say, this is the answer, right? But I have no choice. I have no choice. Exactly as you said, I came to Canada because the culture of Canada is attracting to me. Nobody in China compel me to take a mandatory education on the culture of Canada so that I can make the decision not to immigrate to Africa, not immigrate to South America, but to Canada, because Canada's culture is attractive to me based on my uh, knowledge based on my interaction with Canadian scholars visiting the campus, interacting with the Canadian students visiting the campus in Beijing University, based on my understanding through social media. Nobody imposed me a mandatory education. So I think it's a big irony that this
Mm,
subject is to make me to be culturally competent on Indigenous people. But
mhm,
I can show you with that piece of certificate of achievement of completing the path to you.
mhm,
But still, I'm now blamed by so many misinformed, misguided people as a racist.
mhm,
This subject has nothing to do at all with First Nations.
mhm.
But even
Well,
yesterday
that's
from the media, I saw a chief
yeah.
say blaming 800 Alberta lawyers for being against First Nation. I think in
Mhm,
China, one of the techniques of the authority is to engage the struggle among different classes of people. Okay,
mhm,
that's their game of controlling people. That's their game of keeping in power, right?
mm,
So when I saw this, I mean, it is kind of big division of pro First Nation or pro Indigenous people or someone like me who are against. That's the old game. Now I'm too familiar in China. I think they're
mhm,
trying to this to me. It just reminds me of all this kind of ugly political game and deny of truth, right? So
mhm,
truth can only be accepted and denied, but you cannot change it. The truth
mhm,
is that the lawyers stand up against the indoctrination of the law society. That's the truth. We are not
mhm,
against First Nation people. We are not
mhm,
against the indigenous people. I think
mhm,
I would expect the law society, in order to promote the awareness of First Nation people or indigenous people, they can do a couple of things. They can give guidance on the level of training required, right? If
mhm,
you're
mhm,
advising an indigenous client on the subject of divorce, you have to understand what he or she is coming from, what for
mhm,
background, right? How he got married, that type of stuff. Very specific, right? You
mhm,
cannot just sit in a dark room in front of a computer for 5 hours and suddenly you're expert of Canadian, indigenous
mhm.
people's culture. That's a delusion.
I think the short answer is that I don't see the legal profession or any aspect of it or the plight of Indigenous peoples through the lens of racism. That's number one. But how ironical it is that in this intellectual sense, you were more free in China than you are here in Canada. So, Glenn, you've come up with sort of a working plan now, this vision quest. You're trying to find a name for this new, I guess, collaborative effort of lawyers to try and raise awareness and get organized and really take on this woke ideology. And did you want to talk about that a little bit? What the plan is, and is there a name for it yet? And what does the future hold for that? Or I know we're really in the early stages, but I think this is something that is very exciting and encouraging, especially for members of the legal profession, perhaps for society at large.
Yeah, I mean, I think, well, part of the object of my work right now is to try to see where we're aligned, where the people in the petition are aligned, because as I mentioned earlier, a lot of people signed that petition for different reasons. A lot of people didn't have any problems with I don't think they even detected the ideology inside the path or the ideology that manifests itself in Rule 67.4, or have any problem with the ideology that's otherwise saturated in the Law Society's statutory objectives and stuff. But so I come at it from one particular angle, and my angle would be um, that of a classic liberal, I would say, also an atheist. I recognize that we're a culture that historically has been informed and largely is informed by a Christian moral ethic, and I have no problem with a Christian moral ethic. I just don't happen to believe in that Jesus Christ was the Son of God and that there's such a thing as God. But still turn
We'll
the other
win you
cheek.
over. Roger and I will win you
Yeah,
over.
maybe. Yeah, we'll see. Turn the other cheek. Just the common humanity of people. Love your neighbor like you love yourself, or more maybe. Those are all, I think, beautiful, moral, and important values to hold a country together in a
Mm-hmm.
cohesive, productive way. And I
Right.
think that morality is a big part of the reason that the West was so socioeconomically dynamic and successful, whether, whatever your definition is of successful. But so anyway, I come at it from a slightly different perspective, but I would say I'm what I think most Canadians believe that the law and the Constitution is, which is a classic liberal. I
Mm-hmm.
believe in limited government, which doesn't mean a small government. I'm not necessarily a libertarian,
Right.
but it means that there has to be limits on government, because the bigger
Mm-hmm.
government becomes and the more it invades every aspect of your life, the less freedom you have. Just by definition,
Right.
there's no way past that. So I
Mm-hmm.
believe in that. I believe in the rule of law. I believe in equality before the law. I believe in objective reality. I believe that the way to, I don't believe in, I wouldn't say I believe in truth. Roger likes the word truth, and I definitely understand the importance of truth and the evil of a public lie and the destructiveness of a public lie.
Right.
But I would say the more nuanced kind of scientific Western approach is not so much truth as it is a journey away from error, or perhaps towards truth, but it's the process of finding truth, which is free speech, diversity of opinion, no censorship, empirical observation, reason, the application of reason to empirical observation, and then positing or falsifiable hypotheses that you attempt to disprove, and if you can't, you provide your method, your data, and everything to other scientists to try to challenge and discredit that whole
Mm-hmm.
process towards truth is something that also underpins the successes of Western nations
Mm-hmm.
historically. So
Mm-hmm.
that's, and I think, that was definitely the mindset that both created Canada, that was the reason that Canada succeeded along with other Western states, and the same theory to some extent which informed the charter. Although I would argue that the charter was the beginning of, well, not the beginning, but was a step towards judicial legislation. Let's put it that way.
And secularization of of Canadian society, certainly. If you take, for example, the first big charter case being Big M Drug Mart, and what that did to the Lord's Day Act, that was really the beginning of not only what you talked about, creating an environment in which the Supreme Court of Canada could really determine and set the values for a nation, but also it really set the tone for the secularization of Canada. And we can disagree on this. Roger and I would agree to our detriment. In fact, I'll just mention Michael Wagner, wonderful Alberta author, has written a brilliant book called Moving Past God that talks about this concept. Anyway, Glenn, I didn't mean to interrupt you. Just want to sort of add in and add to your point.
Yeah, I mean, they congratulate themselves on being the most progressive court in the world,
Mm-hmm.
which, again, depends what you mean by progress, but progressive these days means woke. And
Yeah,
so,
it's a
and I,
euphemism. Absolutely.
yeah. And so, a progress towards what, again, I would say it's a progress towards a dark vision for humanity.
Mm-hmm. Gentlemen, this has been a wonderful discussion. I thank you for this time. We're at the part of the show where we sort of wrap up with something called the reading list. And so if the two of you, if each of you have a book or two that you'd like to recommend, or an article or a website, I'm going to come to you and ask you to provide those. There's a couple of books that I'd like to recommend to the people taking this in. One is one that I would recommend to really anyone who's interested in the truth about the Truth and Reconciliation Commission. This is a book that's published by the Frontier Center for Public Policy called From Truth Comes Reconciliation. People who follow this program know that we had the author, Dr. Rodney Clifton, who's a brilliant scholar, Canadian scholar on this program. This book, I actually had the pleasure of writing the foreword to it. It's going into its second edition now, and it tells the truth about the Truth and Reconciliation Commission. And it's not the version that's being told by our federal governments or by universities in this country, or in the Law Society course called The Path. So, Roger, do you have a suggestion or two about resources people could turn to, a book or something of that nature that will enhance understanding of this topic?
if from my bottom of my heart, if you truly want me to recommend a book, I would recommend Holy Bible.
Well, that one has been recommended on
That's
this
it.
program many times before, and it's great because it actually has 66 books, at least the one I read. Glenn, turning to you, do you have a suggestion or two about resources people can access, books they can read that will enhance their understanding of what we've been talking about today?
My kind of two main go-tos are Karl Popper's An Open Society and Its Enemies.
Ah,
Um,
yes. That was not on our
which
list. Thanks for that.
The other one that I would recommend is Hannah Arendt's The Origins of Totalitarianism.
That one is on our reading list, but a wonderful, incredibly eye-opening book. We also had recently a book that was discussed in this program when we had Dr. Robert Malone on. There's a new book by Matthias Desmond called The Psychology of Totalitarianism. And it's a wonderful companion. If people are going to read the Arendt book, the Desmond book is a wonderful companion to that book because it sort of builds on the structure of what Hannah Arendt wrote about in that book. Yeah, that's an excellent suggestion. Thanks for that, Glenn. Just to sum it up, this is a great example of what we've been talking about today. I've been a lawyer in this province for a long time. I'm privileged to be. I'm very proud of that. The lawyers I've known are some of the very best, most principled, most intelligent people that I've known in my lifetime. And I happen to believe that if the Law Society had simply made the information available to lawyers, I would say the vast majority, nearly all the lawyers in this province would have read it, and they would have formed their own opinions about it. And they would have formed better opinions about it, more useful opinions about it than the ones that they have formed through mandatory education. That's my 2 cents, but this happens to be my show. So there it is. Gentlemen, I want to thank you so much. I'm so grateful for having you on the program, and also for taking the bull by the horns and forging a new path forward. I'm very excited about this project that you are putting together, and I hope to be a contributor to it and to help to be part of it. So once again, thank you so much to both of you for being part of Grey Matter today. It's been my pleasure to have you on the program.
Thanks very much for having me.
Thank you, Mr. Gray.